Started. Oh. Good morning, everyone, and thank you very much for joining us for today's webinar, Being the Consultant under Ontario's Revised Construction Act. My name is Shalika Sivathasan, and I am the Administrative Assistant in the Continuing Education Department at the OAA. We will begin today's webinar by acknowledging the land on which we are meeting and calling in from today. For millennia, the place we call Ontario has been inhabited by Indigenous peoples and nations who have been stewards of the land and who are deeply connected to its rich cultural and natural landscape. We would like to invite you in a moment of reflection to acknowledge our shared responsibility to address past and present injustices and provide space for Indigenous knowledge and worldviews to shape the architectural landscape of Turtle Island. Before we begin, I would like to share some important information to ensure an effective and professional webinar experience. Please be informed that this session is being recorded for quality and educational purposes. For accessibility, we provide automated closed caption service available in multiple languages to accommodate the needs of our diverse audience. In order to maintain a stable internet connection, we have muted all participant microphones and disabled video feeds. Kindly note the chat function has also been deactivated. However, we do highly encourage engagement through our Q&A window, which you will find at the bottom of your screen. Feel free to submit any questions you may have for our speakers there. Questions will be addressed during the designated question and answer period at the end of the presentation. For those seeking continuing education at learning hours, please note that attendance is crucial. A minimum of 80% attendance is required for these hours to be accredited to your OAA transcript. Please allow a few weeks for the processing and reporting of these hours. And lastly, please note that the presenters do not provide insurance, legal, or practice advice, and the OAA does not bear responsibility for errors or omissions in discussions during the webinar. Now, I'm very excited to introduce our speakers for today. Please welcome Paige Crewson and Rachel Prestayko.
Good morning, everyone. Rachel and I work with Kennaley Construction Law. We're a boutique construction litigation firm, and we both have years of experience working in construction law in particular. We're going to focus today on the Construction Act. So many of you may already be aware of the fact that the Construction Lien Act changed to the Construction Act in 2018. I know that got lots of press and lots of public comment on it. There have been additional changes that have been proposed to the Act since then. And the goal of today's session is to walk through the Construction Act from the perspective of a consultant. So when we say, well, how does the Construction Act, how does a consultant, what is the relationship of a consultant to the Construction Act? Typically, we're looking at this, or we're going to be looking at this today from the perspective of the consultant being the advisor to an owner on a project and a client. However, there's also there are some provisions under the Construction Act and some changing provisions under the Construction Act which affect the relationship between the consultant and the owner directly as well. So we'll hit on those as well. Rachel, I'm going to turn over to you. Just is there anything you wanted to add to our introduction and the discussion we're going to have today before we jump into our content?
Yeah, I may just add a few comments. As Paige says, of course, we had big changes as we changed from the Construction Lien Act to the Construction Act back in 2018. Some of the changes happening currently were intended to be a 5-year review, see how everything's working, see what may or may not need to be tweaked. So we are seeing some of that, which we'll talk about today, but also some bigger, more substantial changes that you need to understand the practical impacts of. Yeah, so looking forward to being here today and hoping to lend that practical perspective for you as consultants.
Okay, so jumping into prompt payment, keeping in mind we have an hour. The format of the session today is that we'll have an hour to speak about various topics. Again, if you have questions, please don't wait to the end to ask your questions, because if there's something we're explaining you're not understanding, then if a question pops up, we can clarify at the time. Or if you do have bigger questions, by all means, you're welcome to ask those at the end as well. Again, as was mentioned by Shalika at the beginning, we're not here to provide legal advice or to make you experts in the law. We're here to try and give you an understanding, a general broad understanding, and also to help you discover when something comes up that you might need to get real legal advice that's specific to your facts. If you ask us questions today, we can answer those on a general basis, but we don't have the whole background, and so it's a very general discussion and not meant to be specific legal advice for anyone. So, talking about prompt payment. So under the Construction Act, one of the big changes that came in 2018 was the implementation of the prompt payment. Prompt payment and adjudication came together, but this was a new concept that hadn't been in Ontario before. It's been adopted from the UK system, which has now been around for decades, and worked very effectively there. But there have been some growing pains as we take it and apply it in our very different context here in Ontario. So one of the first things that comes up with prompt payment is there is an assumption that often happens with people administering construction projects, or on the bottom layers, in particular subcontractors and contractors and subcontractors who enter into contracts, and they think, well, my contract was entered into after the new act came into force. Therefore, I'm under the Construction Act and I'm entitled to prompt payment. And that assumption isn't necessarily correct. So we have to look at two factors. We have to look at, does the new Construction Act apply? Does the Construction Act apply generally? Does the old Construction Lien Act apply, or does the new Construction Act apply? And if the new Construction Act applies, do the prompt payment and adjudication provisions apply? So there's sort of four different questions to be asked right at the bat as to whether or not you have to, both in drafting and preparing your contracts for your clients, if you're doing that, and also in administering them, you need to ask some questions right at the outset as to what statutory scheme am I working with, if any, when I'm putting this contract together. So does the Construction Act apply? So if we're talking about provincial land, the Construction Act applies to that land. So privately owned land in the province, Construction Act applies. Publicly owned by the province or by a municipality, the Construction Act applies. It will be applied with some slightly different mechanics, but it still technically applies. If we're talking about federally owned land, then that land is not subject to the Construction Act, because under the division of powers we have in our Constitution, we have some powers are assigned to provinces and some powers are assigned to the federal government, and the two cannot control the other. So the provincial government can't create a Construction Act that then binds the federal government on federal land. So if you're dealing with federal land, the Construction Act doesn't apply. Now, some people might say, okay, so if I'm working on a reservation and I'm designing something for reservation, the Construction Act won't apply because it's federal land. That's a slightly different scenario because the federal government doesn't technically own that land. The First Nation has that land. And so some provisions of the Construction Act do apply to Indigenous land. And so again, that would be an area where you might want to seek advice of a lawyer if you're putting together a contract for a client on Indigenous land. So that's about whether or not the construction legislation, whether it be the Construction Lien Act or Construction Act, apply generally. Then we have to decide whether or not we're working with the Construction Lien Act, the Construction Act, or the Construction Act with prompt payment. So Construction Act without prompt payment adjudication, or Construction Act with prompt payment adjudication. And so when we're asking this question, it's about timing. So most people, again, going back to what I was saying earlier, most people look at their contract and say, oh, I've entered into a contract on June 2022, so I'm under the new Construction Act and prompt payment applies. The thing is that when they brought in the new Construction Act in 2018, they used transition language, and you can find that in section 87.3 of the Construction Act. And it says, listen, if this project started back before this new act came into force, then the old Construction Lien Act still applies to it. So this new Construction Act came into force if you have a contract that started, if you have a project, or an improvement that started in or before the 1st of July in 2018, then it's under the old Construction Lien Act. So you're looking at old legislation and you don't have prompt payment, you don't have adjudication, but you're also under the whole old Construction Lien Act. So times for release of holdback, times for registration of liens and liens expiry. All of that is the way it used to be back in 2018, 2017, 2016. The change is, and people think, well, my contract didn't start in 2018, but it's not about when each individual contract started, because the idea was that every project as a whole should be governed by the same piece of legislation. So if the general contractor signed their contract on the 1st of June 2016, and a subtrade signed a contract on the 1st of June 2025 on the same project, then they should be governed by the same piece of legislation. Otherwise, the patchwork of trying to figure out who has what rights where would just be overwhelming for the people administering the project. And so to be grandfathered or not grandfathered depends on when a project was first procured. So first procurement could be somebody ordered a site investigation or hired a consultant or purchased the land and then had a survey done or something. And so there are some real tricks around determining whether or not a project was procured prior to or after either the 1st of July 2018, so whether it's under the Construction Lien Act or not, but also under this other deadline. So when they brought in the new Construction Act, they gave a year before the prompt payment and adjudication provisions will apply as well. So if you are in a project that was first procured between July 1st, 2018, and October 1st, 2019, then you are under the new Construction Act, but without prompt payment and adjudication applying. And so it actually can be quite tricky to determine which date applies to your contract and where your contract falls. One of the things to be aware of, and there's lots of reasons for this, and there's lots of cases going off to court to say, well, we do or we don't have a right to prompt payment and adjudication, because maybe somebody retained a surveyor for a project, but they did it before they owned the land, so they weren't an owner with an interest in the land, and so arguably the project can't start before you own the land because you're not somebody with an interest in the land, so it's not an improvement. And there's lots of legal arguments I don't want to delve into because they'll just be confusing. But it is something to keep in mind. If it is not clear and you're not sure, again, getting advice at the outset of the project before you start entering into contracts might be helpful, particularly in protecting the owner. Because if you decide to apply prompt payment, even though you're not required to, and then somebody tries to adjudicate, if there's a dispute over whether or not there's an entitlement to payment, it might be a lot harder for your client, the owner, to avoid the adjudication on the basis that they were grandfathered under the old act or under the new act, but without prompt payment and adjudication, if you've been acting or if you put something in the contract, or if you've been acting in practice as though the new prompt payment and adjudication provisions apply. So owners aren't in love with the prompt payment and adjudication because it causes them to have to pay money, whether or not they're, and to have this adjudication, they don't have this 2 or 3 or 4 year wait for a construction lien case to happen in court. Adjudication can happen very quickly, and it can be decided that they have to pay. And sometimes that's okay because it keeps the project moving, but sometimes that's unattractive to owners. And so we do find owners, when a dispute has arisen, will often try to avoid adjudication, but they may be stopped from doing that if they're adopting the provisions when they ought not, or they didn't have to adopt them, let's say. So I'm gonna move on from there to talking about when prompt payment does apply. So if you have questions about whether or not prompt payment applies, again, look to section 87.3 to initially, and then speak to a lawyer if you can't work it out from there, and you have concerns if it's not absolutely clear. So then moving forward, we are going to assume that prompt payment does apply in your project. So if you have prompt payment applying, then one of the things, the very first thing you're going to be faced with is the proper invoice. So what is a proper invoice? So there are some statutory requirements, and the actual act defines what a proper invoice is. So it has to have certain information. So you can go to the act and you can look at the definition of proper invoice, and it will include a certain list of items. And it has to have the name of the person who's issuing the invoice. It has to have the name of the person receiving the invoice. It has to have the name of the project. It has to have the date of the invoice. It has to have itemized lists with prices. It has to show HST. It has to show holdback. It has to show a number of items. And then there's kind of an open basket point at the end of the statutory list, which says, and anything else that's required by the contract to be part of a proper invoice. So one of the things we're seeing now in contracts a lot is where the person drafting the contract, which is often the consultant, will put a provision into the contract that says a proper invoice includes everything in the statute plus the following. So we typically see things like WSIB certifications, proof that taxes have been paid, requirements for statutory declarations. Other things do get added there as being contractual requirements that become then part of the statutory definition of a proper invoice. So if the owner is given an invoice that is not a quote unquote proper invoice, they don't have to pay it. The prompt payment provisions are not triggered. And so again, this has become a bit of a problem with the 5 years of experience that we've had now since, or more than 5 years of experience we've had since this came into force in 2019. And so what has been happening is people will go to adjudication, they'll get to adjudication, the owners say, well, it wasn't a proper invoice. And maybe it's some minor technicality, and we're getting kind of mixed responses from adjudicators as to whether or not they say, well, yeah, you have to pay it anyway because you didn't raise an objection at the time, or, oh, yes, it isn't a proper invoice, so the obligation to make payment was never triggered. So in order to deal with that problem, new legislation or new changes to the Construction Act are being introduced, the 2024 changes, which are still under review and not yet brought into force. But there's now going to be a 7-day period within which you can object. So if an owner receives an invoice, or owner and consultant receive an invoice, and they say this isn't a proper invoice because it's missing the following information, they will have to notify moving forward the contractor who submitted the proper invoice within 7 days to say this is not a proper invoice. The Act is not giving a lot of information with the changes as to what happens then. So we are seeing different treatments in contracts looking forward. So for example, some people will say you have to now wait until the next month and submit it as part of your next proper invoice, or you can resubmit it. The resubmission date will be the date of the proper invoice for the purposes of triggering payment obligations, etc. So the Act is not specifying that, but it is going to, if these amendments do come into force, it is going to give you 7 days to object to an invoice, after which time the invoice will be deemed to be a proper invoice, whether it is or it isn't. So an owner isn't going to be able to wait 6 months and then have an adjudication and say, oh, well, it was never a proper invoice because they didn't speak up at the 7-day mark. They now have a short period of time. So if they get an invoice and they don't object to the invoice within 7 days, and or it is a proper invoice, they have 14 days from the date that the invoice is received in which they have to make payment. They have to give a notice if they object to anything in the invoice itself. So there's the form of the invoice. So does it contain all the information it's supposed to contain? Will be under the 7-day deadline, but the actual substance of the invoice will still have the 14-day deadline that was introduced as of October 1st, 2019, which says that if you dispute anything that is in the invoice, you have to let the person who issued the invoice know within 14 days after you receive the invoice that you dispute the invoice. So that process, that 7-day and 14-day process, there's a belief with some consultants that, and it's unfortunate in that our old standard forms in Canada often supported this sort of view. The newer 2020 and forward standard forms tend not to have this problem. But there's sometimes a belief that, well, as a consultant, I can issue a payment certificate So I can make that payment certificate a condition of getting of them giving me the invoice. So basically they have to give me a pre-invoice. I'm going to review the pre-invoice. I can take as long as I want to do that. And then once I agree or disagree and issue a payment certificate, then they can invoice on the basis of a payment certificate. And the act is very clear on the fact that that is no longer allowed. The invoice is the invoice, and you have to work from the date you get it. The only objection you can make is that it's not a proper invoice, and you'll soon have a 7-day deadline within which to do that. Okay, so we get an invoice, and we get to 14. We get to the 14-day. We're in the 14-day period, and we don't like what's in the invoice. So what do we do? That brings us to the next sort of stage in this, which is how to deal with disliking what's there or disagreeing with what's there. So if we have a proper invoice, we're happy with the form of it, but we're at day 12 and we say, actually, we don't agree with what you've asked for. We think you've only actually performed 80% of what you say you've performed. Now you issue a notice of non-payment. So a notice of non-payment, and I apologize to those of you who've issued many of these before and know what they're supposed to be, but there are reasons why we're talking about them today. And that is that we see these notices of non-payments when we're adjudicating on behalf of clients, and we see how they have and have not been completed properly or in ways that actually assist the client when they get to adjudication. So a notice of non-payment, and I'm actually just going to, sorry, I have to maximize my screen for a second. If you'll bear with me, I'm going to share my screen to the window. Sorry, it's a Chrome tab, Construction Act forms. Okay, so if you go, you can just simply Google Construction Act forms. If you Google those 3 words, you will get a link to this screen. But this is the Ontario Court forms for the Construction Act. What it does is it gives you all of the different forms that you would use if you have to give a notice or provide a document under the form. So written notices of lien, owner notice of non-payment. So I'm actually going to open up the Construction Act form, and I'm going to hope that it's going to show on this window, and it's not. Okay, so let me see. I need to share a different window. Sorry. If you'll bear with me, I'm just going to look at the Construction Act form, and I cannot get to my sharing. New share. No. I can't see the form. Share screen, Chrome tab. Cancel. You know what? I'm going to keep talking. Rachel, do you think you could bring it up and share it on your screen?
Sure, absolutely.
While I'm doing that, sorry, I can't. I've downloaded the form.
And sorry, which form?
Sorry, I think I may have closed Zoom on my other account. So I'm going to keep speaking here. So when you're filling in when you get when you get an invoice and you disagree with, can we hear me? Have I been lost?
No, I can hear you still,
Okay.
Paige. Perhaps if anybody has
can't
issues
hear
hearing
you
Paige
on
right now, you can put it in the webinar chat, which I am watching just for any questions as they come up. And Paige, I don't know, would you like me to bring up a form in particular? I don't know.
Form 1.1. Can you bring up Form 1.1?
Sure.
Yeah.
Just give me a moment and I'll bring it up.
Sorry, I should have practiced that one beforehand. I was thinking it would show on my internet screen, but it's not. It's showing in a Word document. So when we get to the Form 1.1, so you have to fill in a number of details. So the name of the owner, the description of the premises, the name of the contractor. If the contractor is represented by counsel, you may be communicating with them with a counsel's address for service, if you know it. There's lots of details, but when you give a notice of non-payment in the Form 1.1, you may find that you end up with some points that you make admissions without realizing you're making them. So for example, if you were to give the notice of non-payment, if you look down, and maybe I'll get you to zoom in if you can, Rachel, on the part where the owner disputes the proper invoice dated X.
Yeah.
So under the current system, if you give a notice of non-payment, you're basically making an admission that the invoice you received was a proper invoice. And the date that you put on this notice of non-payment can be treated as well as an admission by the owner that that's the date the invoice was received. So if somebody, if you receive an invoice and it's dated June 5, but you actually receive it on June 15th, then if you say the owner disputes the proper invoice dated June 5, you could be arguably admitting that it was received on the 5th of June. So in this case, you want to be careful to use the date the invoice was actually received. And I have seen it put in where an owner disputed, or it was actually in another form, it was the form the contractor gave a subcontractor saying the proper invoice was dated X, but it was actually received on such and such a date. They were trying to clarify that they weren't admitting to the fact that the proper invoice, the actual date on the invoice and the date the invoice was received were not the same. So when you're talking about the date here, you want to talk about the date the invoice was received. And that's important because you want to make sure you're giving your notice of non-payment within 14 days of the date of receipt. And you don't want to accidentally admit that the date of the invoice was earlier, causing your notice of non-payment to be out of time, in which case the owner would have to pay the full amount. So that's one of the first potential pitfalls with Form 1.1. And then we get a little lower down and we have to say, in respect of the improvement, they're not going to pay the amount payable under the invoice. One is the full amount of the invoice, so you can just say what the invoice amount was, or a portion of the amount. So if the owner doesn't dispute the whole of the invoice, then you choose item B and you put in the amount that is disputed. And then the owner has an obligation to pay the undisputed portion. So if an invoice is received for $100,000 and the owner disputes $20,000, then the owner is still obliged to pay the $80,000 under the Act within the time for paying. So the time for paying under the Act is also triggered by the date the proper invoice is received. So that date is absolutely critical, and that for a lot of different payment periods and prescribed periods under the Act, because it doesn't just trigger the owner's obligations, but it also triggers the contractor's obligation vis-a-vis the subcontractors and the subcontractor's obligation vis-a-vis the subcontractors, et cetera. So down to the very last section of this Form 1.1 is the reasons for non-payment. And this is where I find people struggle with what they should put in here. And it's very important as a consultant representing an owner to understand that if you don't put a reason down, then when the adjudicator, if it is challenged by the contractor through adjudication, the adjudicator should, and most likely will, restrict their review to the reasons that are given in the notice of non-payment. So if I say, well, the contractor had these three defects, and those three defects were worth this much money, then when I'm adjudicating, the only reasons that I can support and put in front of the adjudicator are those three defects. But if there was also delay and there was a non-payment of a subcontractor and I had to hold back additional money because of something else, and there was this, and there was, there were 10 other reasons that weren't mentioned, I cannot bring those up in the adjudication. The adjudicator won't look at them because they aren't included here in the reasons. And I've seen some very, I'm going to say, lazy approaches to reasons for non-payment. Please see email string attached, and there'll be an email exchange between an owner and an engineer, in the case I'm thinking of, where the engineer and the owner had just said, well, we're not happy with these people and we don't want to pay them another cent, so we're not approving anymore. We're not approving any more payment certificates for this subcontractor. Well, okay, that's not actually a reason. So the only reason is that you don't want to pay them anymore. There's nothing justifying why they're not being paid. And so this is where, even though it's a small space here, you can attach additional documents to the notice that are given. So you can attach, if there's a statement of values, for example, a schedule of values, you can attach where you believe or don't believe that values were achieved, or you can set out the reasons, but more detail is better than less detail, and more breadth is better than less breadth, because the owner can only rely on what the owner most likely is relying on the consultant to draft this document, and can only rely on what the consultant has put in there. So this becomes absolutely critical. Okay, so I'm going to, I think we can shut off the notice of the Form 1.1 notice of non-payment now. So I'm just going to pop back to my.
Paige, if I can, there were a couple of questions in the
Oh,
Q&A.
great. Thank you.
Apologies, I was looking at the chat in the wrong spot, but so this goes back just to what you were talking about at first instance. So I feel like it's good if we cover those off now, when it's fresh in our heads. So one of the questions was mentioning that the Construction Act doesn't apply to federally owned lands, but in some part to Indigenous lands. They ask, what about private lands which are federally regulated, such as CN or CP or ports?
Okay, so they're not, if they're not, well, do you want to answer the question, Rachel, or do you want me to?
No, go ahead.
Okay, so the how we treat land that's owned by sort of quasi-government is that they often because the policy is that we don't want, so if it's municipal public roads or if it's government owned provincial land, the Lien Act would still apply, and it in this case we're talking about private land, so it's not actually federally owned land. But if they're public utilities, for example, we don't want people to be able to seize and sell Ontario Hydro's power station. We don't want people to be able to seize and sell the 401. We don't want people to be able to seize and sell the local library if they do work on those and not get paid. So what we do is we have what we call notional lien rights. So you have a right to lien against those properties, but the lien gets given in the form of a notice of lien rather than being registered against title. And they don't ultimately sell you don't need security in theory, you don't need security in the property, because the government, the taxpayers, have the money ultimately to fund the value of the lien. And so the Construction Act does apply to those lands, but the lien specifically is just treated in a different way. So if you're working on lands that aren't actually federally owned Crown land, then the Lien Act should apply. Again, though, if you have questions about it, speak to a construction lawyer, so that you can get some clarity before you start and know what the obligations are. All right.
All right. And the next question is referring to the number of days in the prompt payment scheme. We talked about the 7-day period where you have to review an invoice, where it may be deemed proper, and that's under the new act that is not yet enforced, or the 14-day periods. Can you please clarify, are those business days or just a Sunday to Sunday period?
So they run as calendar days, so they start from the day so 14 days starts from the day you start counting the day after the event. So if I receive the proper invoice on the 1st of November, then I start counting my 14 days, 2nd, 3rd, 4th, 5th, etc. So we don't count the first and last day, but we count one of the 2 days. So you'd have to, if you receive it on the 1st, you'd have to have paid it by the 15th, or you'd have to have made your notice of non-payment by the 15th, for example. If that 15th happened, so it's specific to the date, the end date is how the act works. And this is typical to most legislation in Ontario, unless it's expressly said it otherwise. So if an end of a period falls on a weekend or a statutory holiday, a typical day when banks aren't open type of statutory holiday, then you move to the first business day after that as the time frame. So if the 15th of November were to fall on a Saturday, then you'd actually have until the 17th of November, because you'd have the 16th being the Sunday and the 17th being the non-statutory holiday, the first business day. So all days are counted under the Act, but if your event or your deadline falls on a weekend or a holiday, then you can push forward. We always try, as lawyers, best practice, and you should try as well, to do things prior to that the last business day prior to the deadline. We try not to leave things to the very last day in case there's an error or there's a technical glitch or something that makes things go wrong, right? We try not to file a lien on the 45th day. We always try to file it on the 44th or the 43rd or the 42nd to give ourselves time, if there's a problem, or if there's a dispute, actually we think you left the site a day earlier than you said you left the site because you weren't actually doing work, you were just picking up your tools that last day or something like that. So yes, it pushes forward, erring on the side of caution. We try to encourage people to push it backward a day rather than forward. Are there any more?
Okay, and no, those are all the questions for now. So I don't know if you want to walk through all of the forms.
No, that was the only form I thought would because
Sure.
it's the one that's most commonly used in the prompt payment scenario. I will just wrap up prompt payment with a couple of other quick comments. So one, prompt payment from an owner has to happen for any undisputed amount by the 28th day after the proper invoice gets received. So even if an invoice gets changed, so if you agree, actually, we don't want to issue a notice of non-payment, and you discuss with the contractor and you say, actually, we think this should be changed, and the contractor agrees and you change it. Even if you change the amount of the invoice or other details or some content, it has to be done by agreement once a proper invoice is issued. So you can't unilaterally require changes, but the parties can agree to change it. But if they do, the act is very express that the original date of submission stands. So if you get a proper invoice on day 5 and you agree to, or the 5th of the month, and you agree on the 7th of month to make some changes and they resubmit on the 8th, your 28-day period, your 14-day period, soon your 7-day period, all get calculated from the 5th, not the 8th. It's from the first date of submission. The date of submission does not change under the act because of other changes. So something to keep in mind. And of course, the payment of the undisputed amounts is still subject to the 10% statutory holdback, which has been around forever and should be familiar to everybody by now. So if, on the example I gave before of a $100,000 invoice where you've given a notice of non-payment for $20,000, you would pay them $80,000, except you wouldn't. You'd pay $72,000 because you'd be keeping $8,000 back as a statutory holdback. So with that, I'm going to turn over to Rachel, who's going to talk to us about holdbacks. And holdbacks you may have been hearing lots about in the news because they are, and Rachel's written extensively and spoken extensively on the changes that are coming. And those are about as clear as mud these days. But I'll leave you in her capable hands for that.
Thanks, Paige. And it is, clear as mud is a good way to phrase it. So I'll do my best here to explain what the changes are. Of course, they are not yet in force and effect. They need to be proclaimed in force. And I will say, as part of background to this, they were rushed through the Legislative Assembly of Ontario. So for a bit of context, lawyer, arbitrator, expert in the construction law sphere, Duncan Glable, worked on a report following the amendments in 2018, which was supposed to be a review of how are these changes working? Do we need any tweaks? And he arguably went a little bit further than that with some of these changes, including this change to a new scheme for the release of holdback. So I'll explain what this scheme is, and we'll unpack a little bit about what you perhaps need to look out for. And some of this, depending on the nature of work you're doing, may actually be beneficial, so it will be important to know about. So the new scheme for holdback, as you're likely aware, because this scheme has been in place for quite some time, the ticking of the release of holdback depends on a few different factors, whether your contract was completed, terminated, whether there's a certificate of substantial performance that's published, or if you're a bit lower down in the construction period, perhaps the last day you're on site. So all of that is going to shift, and the new scheme for the mandatory annual release of holdback is going to tick from the date a contract is entered into. So 1 year from that date, so the anniversary date of when the contract was entered into, is going to start the clock ticking for, and a lot of these obligations are on the owner, but they will have to be working closely with their consultants, I think, to be able to take some of these steps from a practical perspective. So 14 days after that anniversary date, an owner needs to provide notice of the annual release of holdback, and that's the date for publication. So following that year, owners will need to have a sense of, okay, what services and materials were provided and how much has accrued up to that anniversary date of the contract. What do I intend to release, and release that publicly? Now, part of this scheme I'm going to describe is shifting a bit, and this is hot off the press because we caught wind of this just a couple of days ago, but within 60 days of that notice of annual release of holdback being published, liens were set to expire under this new regime, after which time there's a mandatory flow of payments, assuming that all liens have been satisfied or dealt with or paid. So after that date for lien expiry, within 14 days, payment needs to flow of the holdback from owner to contractor. Once the contractor has it, payment needs to flow within 14 days from that contractor to subcontractors below it. So I'm going to unpack a couple of these things. My first comment is going to be just that a lot of us, including us, Paige mentioned, we've written extensively about this. And if you're interested in receiving some of these articles talking about these changes in a bit more depth, what they mean, what they may mean for you, please reach out either to us directly or Shalika. But a lot of people in the industry are quite upset that liens would be expiring on an annual basis in accordance with this, just because it would cause a number of problems. So what is hot off the press this week is that those provisions will no longer be enforced. So it is a little bit confusing to me, and therefore probably to you and others in the industry right now, as to when we remove that, what is this scheme going to look like? So it is something you need to be attuned to. Make sure, even if it's not coming to us, know the latest as to what this is going to look like. So for clarity, this mandatory annual release of holdback is going to apply to all contracts and subcontracts, with a few caveats once this is in force. So those caveats are, number one, importantly, Paige mentioned that the transition provisions, we often say they are complicated, they are quite messy. It is sometimes confusing. Even as lawyers, we're still sometimes leaning on a 45-day time frame just in case an argument arises. So here, unfortunately, they did not make it clear cut, such that, for example, if you entered into your contract 2026 or after, this will apply. That is not the case. It ties into our current transition provisions, such that if an argument is made that the old Construction Lien Act applies, this mandatory annual release of basic holdback will not apply. So this is something you will need either good legal advice or a good understanding of the transition provisions as this is rolled out, to understand if it applies to you, when it applies to you, and when it will start. So it is layered with the current transition provisions. The other thing is they have also given a 1-year grace period for everybody to wrap their heads around this. So if you enter into a contract now, for example, they give you a 1-year grace period. So it won't be the first anniversary where you have to start releasing holdback. It'll be the second anniversary date that you need to actually think about, okay, what has accrued? What do I need to do from here? So I'm going to unpack a little bit just what all of this may mean for you and highlight some questions, because we do get some good questions as we've been going around doing talks on this as parties try to understand what their obligations are and what they need to do. So the first thing I'll talk about a little bit is just that the time ticking from a date a contract is entered into is actually a little bit complicated. On its face, it may be simple, but time and time again, we see contracts where they're backdated, or maybe there is a dispute between a contractor and owner as to what that date is. And it becomes hugely significant because it impacts when holdback is released and how much holdback has accrued to that date. So in construction projects, you're going to want to think about, probably with a little bit more deliberation and intention, okay, let's talk to the owner, let's agree this is the date we're entering into the contract, just to make sure it's clear when holdbacks flow. The other reason is, as I mentioned, it's interesting the way they set it up, that it is all of the services and materials that have accrued to that date. Because practically speaking, when you're talking about retaining holdback under the Act, you should be retaining 10% of the services and materials as they're supplied to the improvement. But what does that actually look like? Are you talking about dropping a dime into a piggy bank, like every day somebody's coming to site? Practically speaking, no, not really. You've got progress applications being provided. You figure out, okay, what work has actually been done? What's the scope? And sometimes those dates don't align with the date a contract is entered into, which can leave somewhat of a gap and lack of clarity as to how much holdback has accrued as the scheme is currently set up. So that's why we are suggesting to parties work together, figure out the date the contract's entered into, so it's clear how much holdback and what holdback needs to be released year over year as this comes into force. Before moving on, I may ask Paige just if you have any other thoughts on that upfront part of the scheme, or I guess the transition provisions themselves.
A couple of points. So one of the things I often see with contracts is that nobody actually dates them. So it's less common here that I've seen internationally, but often the signatures go on the back pages of the contract, and people sometimes date their signatures and sometimes don't, depending who puts the contract together. But if the date of the contract needs to be filled in separately, people often sign that. And it's less common with the standard forms, more common with bespoke contracts, but often there's a gap left for people to fill in the date on which the contract becomes the contract, and it never gets done. So if you have that form of contract that you're working with, make sure somebody actually puts a date on it. It's a silly little, it's a silly little thing. Like the OAA form used to have some standard, some double-sided pages and some single-sided pages, and people would sometimes photocopy the whole contract single-sided, and they'd miss the limitation of liability because it wouldn't form part of the contract at the end of the day. So just these little kind of things that people do sometimes have actually got big impacts at the end of the day. So making sure there's a date on that contract sounds pretty rote, but actually doesn't happen a lot of the time. So there's that. And then I think it's also just talking about transition provisions and holdbacks. Rachel's very much been focusing on what's coming with the changes to holdback. But again, when I was talking earlier about the grandfathering of the old Construction Lien Act and the new Construction Act and the various forms of the new Construction Act, the dates for release of holdback currently changed, right? So before 2018, the liens expired after 45 days after substantial performance, and on that date, the owner is obliged to release holdback. Under the new Construction Act, they have 60 days to register liens, and at the 60-day mark, the owner is obliged and entitled to release holdback. So if you think you're under the old Construction Lien Act, then technically you should be releasing holdback in 45 days. But that's a heck of a risk if it turns out that you're under the new Construction Act, because you're potentially on the hook for that 10% if you've released it prematurely and somebody then registers a lien that turns out to be valid. So you do, if there's any lack of clarity under the existing legislation, or the new legislation as to what the date of your contract is, but also what the date of first procurement of your improvement was. They've been a little smarter, I would say, this time around with using the actual contract date, because that should be clear. But when it comes to the project procurement date under the existing 45 and 60 days, and those will, I think, still apply. Correct me if I'm wrong, Rachel. When we get to the end and substantial performance of the project, we're still going to have that 60-day period under the new act. And I'm not sure how the 45-day period is going to apply if you're still under the Construction Lien Act. I would think you'd still be under the old provisions. So I'll turn it back to you, but there's sort of two sets of grandfathering that we need to worry about, and two sets of transition provisions when we're dealing with holdback. The current issues plus the issues Rachel's been talking about, which are the issues to come.
Sure. And part of this, I'm gonna jump off of something Paige said, because just to be clear, so substantial performance, releasing holdback at that stage does still apply. So I'm gonna walk through perhaps two different examples. So we've had people coming up to us after these types of talks and saying, hey, look, like my contract is sometimes a year, sometimes a year and a half. Are you telling me after entering into the contract, like how much am I going to have to do this, even though my contract is so short? And we say yes, like because of this, it is going to apply to everyone, assuming you're under this new scheme. But on those projects, say for example, it's a year and a half project. Once you hit substantial performance, following the publication of that certificate, you're going to be looking at lien expiries there, release of holdback there. If you hit that first year anniversary date, you're going to have to look at, okay, how much is accrued? What do I need to release at this point? And then, of course, after substantial performance, you may have finishing holdback. So there is this increased administrative burden, particularly for those projects, smaller projects, which may not have had so many releases of holdback for such a short period. You do need to be aware of that. And I think similarly, and on the flip side, so say you do have a bigger, more complex project that takes 5, 6, 7 years. Now, looking at that project, you're going to have to think about, okay, instead of having holdback released once at the end of the project, and I mean once perhaps after substantial, then finishing holdback, you're going to be releasing holdback year over year, maybe 5, 6, 7 times. So going through this exercise that many times. So it does put some administrative burden, and here particularly on the owner, who is the one responsible for preparing this notice, for publishing it. And we think they are going to have like a lot of support from their consultants in doing this, just to understand, okay, how much should I be releasing? Where are we on this project? And I think even more so, so we've talked about this new scheme. One of the other things they've done with these amendments is taking away notices of non-payment of holdback. So this is section 27.1 under the Act, which has huge implications. So similarly, we were at, I think it was in Hamilton, doing one of these, and somebody said, well, how much do I care? Like, can I not just get a notice of non-payment of holdback every year? And we said, aha, like they have repealed that and not replaced it. That is no longer an option for you. So this is mandatory. Every year you've got to think about this. You've got to be releasing holdback year over year for those services and materials that have accrued to these anniversary dates. It's not something anymore that you can set off against, which has big implications, I think, for all of those in the construction pyramid. And I think some of it, it's important to understand there is a trade-off there. So for example, if you're doing work upfront, you're doing it early on these big, long, complex projects, you don't want to be waiting 7 years to get your holdback back, which can be a huge amount and part of your profit that you're waiting for that project. So part of what they're trying to balance here is the need for people to get their holdback early, while still allowing projects to flow and function properly. So perhaps I may punt it over to Paige here just to maybe talk a little bit more, if you have comments, just about the administrative complexity of implementing this regime.
Well, personally, I think it would make more sense if they were to require the certification of subcontracts, of every subcontract to be certified complete. Maybe not at the subcontract level, but the real problem I think that's trying to be addressed is that subcontractor, if you're an excavation subcontractor on a 7-year project, you're not getting your whole back until the whole project is substantially performed under the old regime. And so they're trying to address that, but I'm not convinced that the approach that they're taking as a broad brush, just annual release of holdback to everyone is going to work. And we've got all sorts of cases we could dig into on where, lien rights get reopened if you then come back and perform new work. So now they've released the holdback, but you have lien rights for work you performed 5 years ago because you came back to the same project and continued in the improvement. Like, there's a lot of gaps and holes. So administratively, I think, again, I honestly think it's a little premature to worry too much about how you're going to have to implement this from day to day, unless you have something specific in mind, Rachel, because we still don't know entirely. We don't have certainty yet that this is passing in the form that's in. We've seen draft regulations; they haven't been adopted yet. Some changes are already being seen, so I think this is a space more for us to continue to watch. I would. Did you have anything else, Rachel, you wanted to hit on with holdback? I was going to move on to sort of other concerns.
No, I recognize. So we're a few minutes to noon. So I'll let you go ahead and then we'll see. Right now, we don't have any other questions coming in. So I may add a few more comments later, just if we have a little bit of time.
Okay. So a couple of other things to be aware of. So one is construction trust. So under the Construction Act and under the Construction Lien Act before it, anybody who's a payor or anybody who receives funds on a construction project is a trustee of those monies. And that is often a big shock to people on construction projects. It's a piece of the act that's been there to protect people who are lower on the construction pyramid for decades, but it is not something that people seem to have huge awareness of in the industry. And so this is something where you can really add a service to your clients by helping them to understand their obligations as a trustee. So if you have an owner who has received funding or financing in order to make an improvement, so you have somebody who is taking out a mortgage to build a home, you have somebody who has, a big, revolving line of credit to build a giant condo tower, whatever it is that they're building, if they're receiving funds from a third party, those funds are impressed with a trust. The beneficiary of the trust is the contractor or contractors who have direct contracts with the owner. So those monies in the hands of the owner do not belong to the owner. The owner is merely holding them as a trustee for the contractor. So that means that they have, when you think of a trustee, we tend to think about estate trustees, and we tend to think about, somebody holding a trust fund for a minor, for example. And a trustee has a fiduciary obligation. That means they have an obligation to put the interests of the beneficiary of the trust ahead of their own personal interests. So an owner who misappropriates the funds. So say they decide, say you have I'm going to look at experiences I encountered in Dubai. You have a developer who's building multiple projects and they receive funding directed for one project and then they haven't finished another project. So they decide to use the money they've borrowed to get that project complete because they need to do it and they're falling behind. That would be a breach of trust because the money that they received isn't their money. It's the money that belongs to the contractor on the improvement they received the funds for. And so by using those funds for another purpose, the company, the owner development company, has now breached their trust obligations. And so there's some pretty serious consequences because not only is the company responsible for breach of trust, but the officers and directors of the company, people who controlled those funds. So the bookkeeper who diverted and wrote the check or made the transfer out of the account can be personally liable to the contractor who doesn't get paid because the trust funds were misappropriated. So the Construction Act, one of the newer things in the Construction Act is that there's a requirement for anybody who's a payor or a recipient of trust funds to hold those funds in a separate trust account. So looking at it from a contractor's perspective is a little more straightforward. So I'll use that example, even though we're dealing more likely we're dealing with owners in your situations. But if an owner or if a contractor receives money, they receive a payment from an owner on a construction project, they can put that money into their trust account. Now, if they have 5 different owners they're working for on 5 different projects, they can put all of the money that they receive on all of 5 projects into a single trust account if they want to. But they have to keep very clear records on what funds came in on each project and what funds went out on each contract or project or improvement, to make it clear. It's easy to trace the funds to make sure that the trust funds were paid to the trustees. The only way to extinguish the trust obligation is to pay the beneficiaries under the trust. So a contractor who pays the subcontractors on the correct improvement is extinguishing their trust obligations to the extent that they've made those payments. So until the subcontractors who are owed money are paid, that contractor will remain a trustee. And again, any money that's used on another project or used to pay their own personal overheads or taken out as dividends is an appropriation of trust money and could be, and the people who are involved and in charge of the money and the company could become personally liable for those funds. So similarly, an owner, so if you work with a developer who has multiple projects, if they're receiving financing, that financing needs to be put into a separate trust account. What is okay is mixing the trust account together, using the example I just used with the contractor. If they mix the trust funds from multiple improvements into a single account, that's fine. What they can't do is commingle the other money and revenue and funds that the cash flow through their business. So you cannot take your employee salaries and your tax your tax remittances to Revenue Canada and your WSIB payments and things. They can't come out of your trust account, and similarly, funds that aren't trust funds can't go into it. And so an owner who's receiving money from a lender should be alerted to the fact that they should have a separate account into which those trust funds are flowing, unless the trust funds are flowing directly out of the lender's account to the contractors. So that's something to keep in mind, because it's something people tend not to be aware of. Even contractors tend not to be aware of. And it could be something you could require, you could add contractual provisions that they'll have a separate trust account for your improvement so that your funds are easily traced through the contractor's accounts and that they don't commingle with other trust accounts. That could be something you could ask for in a contract on behalf of your owner to make life simpler. The other, I guess, a couple of other things we were talking about, Section 39 demands, as some of you may have seen these before. Again, they wouldn't be issued to you as a consultant. They would be issued to the owner, but you'd probably be the one helping the owner respond to them. So under Section 39 of the Construction Act, any person who's entitled to payment, any person who has a right to a lien, so anybody who's supplied services or materials to the improvement, has a right to demand certain information from the people above them on the construction pyramid. And the owner is one of those people. Lenders are also potentially could receive Section 39 demands. And so a Section 39 demand it's mandatory to respond to it. There's a period, it's as soon as reasonably possible, but no later than 21 days. And the Section 39 demand will basically ask information about, what is the state of accounts? Is there a labor and material payment bond? Has the contractor been paid? And it's actually, I think, in the interest of the owner to give information. One of the problems I find in the current iteration of the Construction Act is that there is very little way for the subcontractor to get information about things like when payment was actually made to a contractor. So there are ways. So if a notice of non-payment comes out, for example, it has the date of the proper invoice, but otherwise, without asking, the subcontractor has no way of knowing when the proper invoice was given to the owner. So they have no way of calculating when the 35-day period is, when they're supposed to be paid, when they're entitled to start being paid interest, if payments are late, etc. And so what we often find is, subcontractors will approach the owner when they're not getting paid, and then the owner sort of clams up a little, and they want the subcontractors paid, but they sort of want the contractor to deal with it. But actually empowering the subcontractors with information by responding to Section 39 demands can be, I think, helpful in preventing escalation of disputes, because it gives the subcontractor enough information to determine whether they ought to or ought not to have been paid. Because what will often happen, right, is the owner will say, well, I paid the contractor. The contractor will say, well, the owner didn't pay me. Section 39 demand forces everybody to put that information down clearly. And there are consequences for putting false or wrong information in a Section 39 demand and for not responding to it. And so, again, assisting your client to be kind of full and frank and correct in that information is an important thing. The other thing is Section 6.6 sub 10 allows a subcontractor who has to give payments to their subcontractors to ask for information about when the proper invoice date was, and the time for response in those is as soon as possible. And it's because, from the date the contractor receives payment, they have 7 days to pay the subcontractor, and if they haven't paid, the subcontractor has so many days. From that 35-day period, if they haven't been paid, they only have a period of time within which to notify their own subs and suppliers that they haven't been paid and they're not going to make the payment. But they have no way of determining when that 35-day period expires because they don't have access to that information. And so if your client receives a Section 6.6 sub 10 request to know when was payment made or when was a proper invoice given, it is in the interest of the owner to actually respond to those, because what we don't want is people sort of closing the doors and saying, I'm not giving you any more supplies, or I'm not doing any more work in your project because I'm not getting paid. And then that just ends up backing up the whole project. So that's a bit of an issue. Have we had any more questions?
Yes, actually, there's quite a few questions. Sorry, I didn't mean to appear and cut you off, but there are a few questions in the Q&A box. So I can go ahead and read them out to you. This first one is from Khaled. It might have been something you've already addressed, but maybe if there's anything more to add to it. Khaled's just asked, what's the purpose of a notice of non-payment, and is it mandatory to do it and to use the specific form?
So I'll field that one. So it is not mandatory to give a notice of non-payment unless you don't want to pay. So if the owner does not want to pay the contractor some or all of an invoice, then yes, it is absolutely mandatory that the notice of non-payment be given in the proper form and be given within the time frame, which is 14 days from the date the invoice is received. So yes, it is absolutely mandatory. I have had success at several adjudications on behalf of people who haven't been paid, where we've just gone and said they didn't serve a notice of non-payment, or they didn't serve a notice of non-payment on time. And that has been enough. We don't have to argue over the legitimacy of the invoice. We don't have to listen to what the owner has to say about why they shouldn't have to pay because the owner didn't follow the rules in the Construction Act. And one thing, just as a general concept, is the Construction Act is statutory legislation. It's remedial in nature in the sense that, if you were to just talk about contracts, we have the owner and the contractor have a contract. The contractor and its subcontractors have a contract. There is no contractual relationship between an owner and a subcontractor or anybody else further down the chain, right? The whole point of the Construction Act is to bridge that gap, because an owner or a subcontractor cannot sue an owner for breach of contract, right? If a subcontractor improves premises, the owner gets the benefit of that improvement. The subcontractor has no way to enforce if the owner doesn't pay for it. They have to sue the contractor has to sue the owner. What if the contractor doesn't exist anymore? What if they've gone bankrupt? What if they're not inclined to sue the owner? Subcontractor's left holding the bag. And so the whole purpose of the Construction Act is to create that relationship where there is no contractual relationship and to protect the people who are down. But for everybody, the Construction Act remedies. So it is a remedy in a way to an owner to say, no, actually, I don't have to pay you because this didn't happen. Give you notice of non-payment. They very much require absolutely strict adherence to the provisions of the Act. So if you miss a deadline under the Act, you no longer have the rights you would have had you not missed the deadline. So yes, not only notices of non-payment, but everything, the timelines in the Act are absolutely strict. So yes, I would say definitely required. So next question, sorry.
Thanks, Paige. Yeah, no worries, no. So the next question is in reference to the form. So they asked, not sure if I understood correctly, did you say that though the NNP form states invoice dated, we use the date that was received by the consultant?
not the consultant, the owner.
The owner.
So a proper invoice under the act is given to the owner. And I see consultants will, I can tell when a consultant has gone through and amended a draft contract. And that I can tell when they don't understand the Construction Act, because they'll change the payment provisions and they'll change the notice provisions and they'll start crossing out the owner or the consultant. The owner has to receive a copy of the proper invoice, not just the consultant. It has to go to the owner. And the day it goes to the owner is the date that I would use if I was filling in a notice of non-payment. So it's not the date of the consultant, but yes, it's the date it's received, not the date that somebody stamps on the top of the document. So
Okay, great. Perfect. So our next question is from Carrie Hunter. She asks, this incremental release of holdback sounds very time consuming for consultants. How do we know how to anticipate our required fees?
I'll jump in and try to field it. I'm curious if Paige has thoughts too. From my perspective, though, it will be time consuming for consultants, and you've got to think about perhaps if you're administrating contracts, how you may want to price that. And I know, just understanding from the construction industry, sometimes the administration of contracts is a loss leader. You will have to think about how you may want to change in the drafting of your contracts in the face of this rolling out. And I will say a couple of other things on that point. I think in terms of administering the contract, you have to remind yourself that so you're going to be not only in terms of release of holdback, you're also perhaps going to be more involved in looking at proper invoices and helping owners within 7 days say, is this proper or not, which is also an administrative burden. And I think that, coupled with, I talked about the repeal of the notice of non-payment of holdback. So just to ground that in an example, we often see situations where owners, they've got this pot of money at the end of the job. They said, hey, contractor, though, like there are all these deficiencies and things like that. There's no way I'm going to pay your holdback in the face of these deficiencies. Without that ability in section 27.1 to withhold for those types of reasons, you've got to pay that holdback out, which is an increased risk for owners. So we have seen a shift in talking with some owners. They're thinking about, okay, if I'm taking this extra risk, I want deficiency holdback, or I want other holdback in my contracts now in the face of this perhaps rolling out. So I think there are a few different factors that consultants need to be thinking about, but also in entering into contracts in anticipation of this coming out, thinking about if they may want to price differently. I'm curious though, Paige, what are your thoughts on that?
I was just going to add there a couple of thoughts. First, yes, both of the two things that you mentioned, the prompt payment regime and having to administer the 7 days plus the 14 days plus the actual possibly being involved in the transfer of funds, et cetera. So there's all of that happened before, but is now a little bit more of an administrative burden than the non-payment of holdback, or the payment of holdbacks annually is going to be a big increase, but also the possibility of participating in adjudications. And it's unfortunately we ran out of time. We didn't really get to talk much about adjudications, but so far in my experience, I've done 20 or so adjudications now, and I haven't yet had one where the consultants actually actively participated. But I think that's probably going to become more common, and assisting the owner to prepare for adjudication and helping them through adjudication is another area where you may find that your services are needed. And I have seen it in the past that it does tend to be, if there's a dispute of any nature, whatever, I'll help the owner, but I'm doing it at hourly rates or whatever. So I think there's 3 areas where we're potentially going to see more cost escalation in terms of the involvement of consultants. And so I guess my recommendation would be that for now, it may be better to include, provisions like we'll discuss it when and if it happens, or, the consultant, is entitled to hourly rates for certain scopes of work. I imagine that as this starts to take hold more in the province, that the OAA form, we may see some updates to the OAA form to address this. But until that time, yeah, I think you're wise to think about the impact if you're quoting a fixed lump sum or something for your services administering contracts. Because it is going to become, I think it will eventually become easier as you have been through the process a few times and you're able to give a better sense of how much time is involved. You won't be able to do that with adjudications, but you may be able to do that with holdback. But it will take some time and some experience. So yes, protecting yourself with some get out clauses or some, I reserve the right to charge more money if, annual release of holdback comes to the fore.
Great, thanks. So we have another anonymous attendee asking, are there no situations where it would be legitimate to issue an NNP for HB?
Right. So perhaps I'll answer that as well. So what I think they're asking is, are there still situations where it's legitimate to issue a notice of non-payment of holdback? The answer is yes, assuming you're under the Construction Act. So that is kind of, it's subject to which act you fall under, which is a little bit messy just because of the transition provisions. So hopefully it's been clear in doing this talk. So some of the changes I was talking about and the repeal of the ability to send that's not enforced yet.
Yeah. So I think just to add to the clarity of that. So at the moment, yes, there are you can issue a notice of non-payment of holdback if you have legitimate reasons to dispute that holdback is payable. Once the new changes to the legislation, the 2024 changes, once they actually come into force, at present, there isn't going to be any situation in which you can issue a notice of non-payment for holdback because that form will no longer exist. Is that a fair summary? So at the current state, you can still do it. Going forward, no, and that's a problem that's been identified, and we're hoping that we see change there.
Great. So next is Chris, who has asked, was there not a provision for early release of holdback under the Construction Lien Act?
So perhaps I can answer that. And I didn't want to delve too much into the context surrounding. So when we moved from the Construction Lien Act to the Construction Act, that was when they implemented Section 27.1, the right to be able to set office against holdback. And that was due to some of the practical realities that I talked about, where, for example, if there are deficiencies in work, other valid reasons that you may not want to pay that holdback out, that you have a means to do that. And at that point, it was Reynolds and Vogel who canvassed with many stakeholders, came out with a report and thought, okay, this balances the rights of lots of parties, and parties are generally agreeable to this. And I guess, sorry, and I'm pausing just because I'm talking about, I don't know if I'm answering the question correctly. So the early release of holdback, yeah, I'm so focused on the notice of non-payment of holdback. Let me rephrase that. So in that shift with Reynolds and Vogel moving from the Construction Lien Act to the Construction Act, in addition to notice of non-payment of holdback, they actually did provide a couple of mechanisms to release holdback early. And that was to resolve this problem of people coming on the project early, supplying services and materials to that project. And they're like, look, I don't want you to hold on to my $3 million for 10 years. Like, I want it now. I've done the work. So to try and provide an option to do that under the Construction Act, and as it currently is, you can release it early. And there's a couple of situations where that can happen. So where an owner and a contractor agree to release it on an annual or phased basis, they can do so, but they've got to include it in the contract. And for annual release, it's got to be a certain threshold for the contract value for them to be able to do that. So that is possible.
Which is quite a high threshold. I think it's 10, is it 10 million?
I think it's 10 million, yeah.
Yeah, it's a really high threshold.
And the other mechanism in place for the early release of holdback is for subcontractors, where you can have deemed completion so that you're able to release holdback early for subcontractors who may have been in early. One of the things that was commented on by Duncan Glayholt was that there was little to no uptake of these mechanisms and that they really needed something a bit broader and a bit more forceful to help I was going to say these provisions to have teeth, but it is kind of like a broad brush, like this is going to apply to everybody. So I hope that answers the question, Paige. I don't know if you have any other thoughts on that.
Yeah, again, because we're dealing with consultants who are helping owners, I actually think it's in the interest of the owner somewhat. People like to hold on to their money. They don't necessarily want to give it away, right? Why would I give up my holdback now when I can pay it 3 years from now? Because I can continue to earn interest on it or not have to pay it or not go into debt to pay out these subcontractors. But if you look at it from the perspective of a subcontractor, so I'm a subcontractor. I'm going to say I'm an excavation contractor because we know they're in early, right? I'm on a project that's going to last for 3 years. So, but I'm done in the first 6 months. So now I have to wait 2.5 years for the last 10%. So on every project that I work on, I have to maintain this 10% cash flow problem for the next 2.5 or 3 years or however long on every contract. So it becomes a problem for them. The other thing is they have to trust that eventually when that holdback gets released, that contractor is actually going to pay it to them because they're out of lien rights, right? Their lien rights expire 45 or 60 days, depending on the act, after they've left the site. And so if they don't have a great relationship with a contractor, are you going to, as an owner, get a whole bunch of liens because people haven't had the payment of their holdback and they're worried because, oh, this contractor just stiffed me on this other job. What if they stiff me on this one too? Am I better to register a lien? Am I better to rattle my sabers? There's really nothing out there other than the intention of having, an early certification or of substantial performance of the subcontracts on a 1-by-1 basis for those types of subcontractors. And so it's a shame that uptake hasn't happened. And I actually would urge, from a perspective of avoiding disputes, it's actually better for the owner not to have liens registered. And contractor also can't afford to pay out the subcontractor. Subcontractors most likely paying its suppliers in full and not holding holdback back from them, and so they end up wearing this for quite a long period of time. It's and particularly if you're working with an owner who builds over and over and over again, it's in their interest to have good relationships with the subtrades. They'll get better prices on the projects. That's the only way. Yes, there's some competition, but the way to manage cash flow arguably can be to just increase the price, so that they're getting the full amount of what they need in order to stay in business, and that 10%, if it comes in later, isn't a problem. So anything that protects the owner, in theory, probably costs the owner in terms of actual monetary cost of doing the work. So just something to keep in mind.
Okay, so I see that we have quite a few questions left in the chat, in the Q&A box.
Yeah.
I don't think we'll have a chance to get to all of them. So those of you, unfortunately, if we don't get to your question, I'm sure you can reach out to Rachel or Paige if you have any specific questions. But I think maybe we have time for one more. So this is a question from Tina, who asks, what happened to the release of holdback on completion of a subcontract under the proposed changes?
Which is a great question. And I think this, I would have to think through this a little bit, to be honest. My instinct is, though, partly because of because this is kind of moving ground in terms of expiry of lien rights is part of what I'm thinking about. But I think my instinct is, so as regards to subcontracts, that holdback would have to be released on an annual basis. In accordance with everyone else. I think that option is still on the table, though, to have it deemed completed and release it early if possible.
I haven't seen anything that repeals the ability to certify a subcontract separately, but I'm not 100% certain. I don't recall seeing anything that does that. But again, it's still moving. It's still very much moving ground, so we don't know where it's going to end.
Okay, so maybe we could take one more. So This question is from Khaled, who says, is there a method to registering a lien without hiring a lawyer? I understand TerraView is only available for lawyers, also for perfecting the lien and issuance of statement of claim.
So in terms of perfecting a lien, the issuance of a statement of claim in theory doesn't need a lawyer. Anybody can go to the courthouse with their statement of claim. I think you can still walk in person. It's been so long since I've done that. And issue a statement, get your statement of claim issued, commence your action, and get your certificate of action. But in terms of actually registering documents in Land Registry Office without a lawyer and doing that online, I actually don't know. Rachel, do you know if people can still walk in and do that manually these days?
I don't know either. Yeah, I'm not sure of an answer for that one.
It used to be. I mean, there's still Land Registry offices. I think that's probably the best place to start to ask that question. So in the old days, you know, claim for lien, it used to be typed onto a form and we'd walk it in and they would take it and register it and file it away. You know, the pieces of paper were actually there. So there may still be a mechanism to do that. You may be able to purchase the TerraView software without being a lawyer. But I'm not 100% certain what the guardrails are on that. So I'm sorry, I can't answer that question. I know you can start an action without a lawyer. I don't necessarily recommend it because there are, you know, a lawyer who represents himself as a fool for a client, as the expression, and that's somebody who has training and a law degree and some understanding. And so as a layperson, unless you're talking about a very small value claim. And when you are talking about a very small value claim, if you go to a firm that does construction law as kind of a bread and butter thing, they sometimes have summer students or articling students or somebody, they will give smaller things. They'll give them smaller scopes of work to do, and they may do it as a bit of a loss leader to give the student some experience in dealing with those. So you're still getting somebody who's being supervised by a lawyer, but somebody who's able to help you do those things. So I don't know if this is still the case, but years ago, when I worked with Duncan, who's been mentioned several times today, I was an articling student with Duncan, worked with him for a few years, and I remember some of the advice that I got from him around. Sorry, totally lost my train of thought now. Registering and perfecting a lien, acting on your own behalf. He was at that time. Our firm represented lawyers, and we represented the lawyers' professional indemnity company, which is the insurance company for lawyers. So our professional indemnity insurers. So if a lawyer makes a mistake, our professional indemnity insurance company hires another law firm to go in and try and work on behalf of the original client to get them the remedy that they would have had the first lawyer not screwed up. So we were the firm that did the construction law things. And at that time, now I worked with Duncan 25 years ago, but at that time, we were told by the Lawyers Professional Indemnity Company that Construction Act and Construction Lien Act then, Construction Lien Act mistakes were the single most common source of lawyers' negligence claims. It is an extremely niche area of practice. It shouldn't be confused with real estate law, and it is something that lawyers who don't practice in regularly make a lot of mistakes in. And so I wouldn't recommend that a layperson necessarily take on a construction lien matter into their own hands if they can in any way afford to get some help, because it is a very specific niche area of practice. And as I mentioned before, if you miss a deadline, your rights are gone. And so, but there may be ways to get them back. They're probably going to cost more because you're going to have to do a lot more finagling to try and push forward through another route rather than the straightforward one. So, you know, a piece of advice I once read was spend your money on your financial advisors and your lawyers because they make the most difference at the end of the day. So I'm not trying to give a plug for lawyers or law firms or our law firm in particular or anything. I'm just saying that it is a it is an area where if you're getting into actual liens and you're getting into actual statements of claim and things, you probably do want advice. And if you're representing an owner, you probably need to advise the owner to get advice. You know, we're not architects. We wouldn't want to design a building.
Sorry, Paige, I do want to add one thought there.
Yeah.
And it's just depending on, and it's interesting because as Paige mentioned, some of us who like construction law is our bread and butter. If we have people coming to us talking about liens of a certain value, we tell them pretty off the bat, like, you're going to spend more in legals if you lien on this amount owing. It's not worth it, which in my mind is interesting because often those amounts will suggest like the threshold jurisdiction for small claims court used to be $35,000 or less. So say if that's the amount owing, we may suggest small claims court. That threshold has recently increased to up to $50,000. Which in my view is not an insignificant amount, depending on what you're trying to recover, and is also just a more cost-effective way of seeking returns for those amounts. So that's
and
what
you can do that yourself. You don't need a lawyer for that.
Yeah, you don't need a lawyer. You can represent yourself.
And if your claim is, sorry,
no, go ahead, Paige. Happy to.
This is a thought I had in my mind as well, and I hadn't articulated. So thank you. If you have a claim for $60,000 or 55 or 65 or 75, it might be worth still going to small claims court because you can still, you know, it's better to recover 50,000 than nothing. And you may not have recovered the whole amount in any event. And so that's certainly another option. So, but if you're talking substantial amounts of money, then by all means, at least have a consultation with somebody. And then they can suggest to you what other options you may have. You know, you may. So, for example, if you're a consultant and you're on a matter, now we never got back to this point of talking about how. So under the Lien Act, under the old Construction Lien Act, it wasn't clear, and under the new Construction Act, they've made much more clear. And there's new amendments coming out making even more clear that architects and engineers who provide services to an improvement have a right to lien, right? They have lienable work that they've done. And as a result of that, if it's you who hasn't been paid, you may have a right. If you haven't completed your work yet and you meet the criteria, you may have a right to an adjudication. If you haven't received a notice of non-payment and they haven't paid you, they don't have much of a defense to that. So don't forget that as we're talking about the owner administering the contract on behalf of the owner dealing with the contractor, under the new Construction Act, you have rights you didn't necessarily have before, and the protections and things contractors have done that you've been seeing are available potentially to you as well. And it may be worth, that's where that consultation may come in handy, where we say, actually, you don't need to register a lien. Why don't you just bring an adjudication? They didn't give you a notice of non-payment, right? Owners aren't giving those to consultants because they may not be aware of them. If you've issued a proper invoice, again, go back and look at the act and make sure your invoice is conformed to what a proper invoice has to be. That would be something I would suggest all of you do in any event as a matter of good business practice, so that if you do have a problem in the future, you could argue that you've issued a proper invoice and haven't been paid on an improvement. So these protections that are there aren't just for the contractors and the people who are, the hammer and nails folks. They're also there for the designers. So that's a new large advantage. So, and again, legal counsel, someone came to me and they're like, oh, our lien rights have expired. What can we do? And we're like, well, it looks like the owner on this project was receiving funding. So it looks like you probably have a breach of trust claim. So there are other ways through, and, even maybe an hour or two might be worth a little bit of advice so that you can make some educated and informed decisions about where to move forward for your next steps. So. Anyway, well past 12:30 now. Sorry.
Yes, that's okay. So it's a great advice to leave us off with. So thank you so much, Rachel and Paige, again, for this really informative presentation. I'm sure our members took a lot from it. I do have just a few quick announcements before we close. So again, for those who are seeking continuing education hours, the OAA will record your participation in this webinar on your OAA transcript. So there is no need for individual reporting. We just kindly ask for some patience, as this is a busy time of year. So we need a little bit of time to process and confirm the accreditation of those hours. So it'll be within the next few weeks. As well, all attendees will soon receive an email. We're going to include the links that were mentioned in today's webinar, as well as a link to a survey for feedback. So we really appreciate, and our presenters appreciate your feedback as well. So please do fill that out once you get a chance. And then finally, our next webinar takes place next week on Thursday, November 13th, with the title Conversion and Underutilized Commercial Office Space to Residential. And just a quick note about this webinar that there has been a speaker change. So instead of Principal Denny Paletti, we will have Project Manager and Senior Associate Daniel Lee presenting on the project. So that's next week, Thursday, November 13th. So that's it. So thank you once again, everyone. Thank you to Rachel and Paige and for everyone in attendance, and have a pleasant remainder of your day. Thanks.
Thank you.
Thanks, everyone.